Okay, imagine for a second your whole digital life. Every click, every search term, every single purchase online, it's all out there, building this huge digital picture of you.
Yeah, it's kind of staggering when you stop to think about it.
Exactly. Now imagine having like a digital bodyguard for all that information, a new set of rules designed to protect it.
Well, that's not so imaginary anymore, especially in India.
Precisely. And that's what we're diving into today in this deep dive. We're unpacking something really significant, especially if you're in India or do business connected to India. We're talking about the new Digital Personal Data Protection Act of 2023, the DPDP Act.
And our goal today is pretty straightforward. We
Hmm.
want to demystify this thing, cut through the legal speak. We spent a lot of time going through the act itself and also the crucial draft rules for 2025.
Right. We want to give you the key takeaways, those aha moments, so you can quickly get a handle on what this means for you, your personal data, and honestly, the wider global economy, too.
It's really about empowering you with that knowledge quickly but thoroughly.
And here's something really interesting and timely. The draft rules for 2025. They're actually open for public feedback right now until February 18th, 2025 on the Innovate India platform.
Yeah, that's a crucial point. It means your voice, your feedback, could genuinely help shape how this law finally works in practice. Finding that balance between protecting privacy and letting businesses operate globally.
It's a living thing, still being fine-tuned.
Exactly.
So, okay, before we get into the nitty-gritty of the act, let's set the stage a bit. Why is data protection such a massive deal right now, globally?
Well, it really comes down to the fact that our personal data, and we mean everything from your name and address, sure, but also your browsing history, what you search for, maybe even your pet's birthday if you've entered it somewhere, has become incredibly valuable, like digital gold.
Right.
And it's constantly flowing everywhere, across borders, through countless apps and services. The sheer scale of it makes protecting it absolutely vital.
It's this invisible river of information, and India's path to this specific act, the DPDP Act, it's been quite a journey, hasn't it?
Oh, definitely. For a long time, the rules were kind of scattered. You had the Information Technology Act of 2000 and then some rules added in 2011. They covered some ground, but it wasn't a dedicated, comprehensive data protection law.
It was more piecemeal.
Exactly. Then came 2017. That was the real turning point. The Supreme Court, in a huge landmark ruling, declared that privacy is a fundamental right, part of Article 21 of the Constitution.
That Swami judgment, yeah.
Precisely. That ruling really paved the way. It established the constitutional foundation, you could say, for something much stronger, leading directly to the DPDP Act finally being passed on August 11th, 2023.
So, with privacy now locked in as a fundamental right, what's the core job of this DPDP Act?
Think of it like this. Its main job is to make sure your personal data doesn't end up misused or in the wrong hands. It's about safeguarding it.
Like a bouncer for your data.
Yeah, kind of. But a smart bouncer. Because it also needs to let the legitimate players in businesses, services that need data to function. If you block everything, the whole digital economy, the club, as you put it, grinds to a halt.
Right, you need the club to stay open.
Exactly. So it's this really delicate balancing act, protecting individual privacy very strongly, but also allowing data to flow where it's needed for innovation and, frankly, for the economy to work, especially in a global context. That tension is what makes it so interesting.
Okay, so to really understand how this works, we need to know the main players. Who are the key characters in this data drama?
Right, let's meet the cast. First, and most importantly, there's the data principal.
That's you, listening right now.
Exactly, the individual whose data is being collected and processed. You are the star of the show, really. The Act gives you specific rights over your data. You're not just a passive subject anymore.
Okay, so the data principal, who's next?
Next up is the data fiduciary. This is the organization, the entity that decides why and how your personal data is processed.
So the company running the app, or the website, or even a government body.
Precisely. It could be anyone collecting data. They're the ones primarily responsible for following the rules in the Act. They're kind of like the caterer at your data party. They're handling the goods,
Yeah.
and they have to do it properly.
Got it. Data principal, data fiduciary. Is there anyone else?
Yes, there's often a third player, the
Yeah.
data processor. Sometimes the fiduciary hires another company to actually do the processing work on their behalf.
Like a subcontractor?
Exactly like a subcontractor, maybe a cloud provider or a data analytics firm. They work under the instructions of the fiduciary, but they also have responsibilities under the Act to protect the data they handle.
Okay, that makes sense. Principal, fiduciary, processor.
Hmm.
So knowing who's who, let's talk about the power shift. What rights, what tools does this act actually give you, the data principal?
It's quite a toolkit, actually, really empowering. First off, there's the right to information, meaning you can ask the data fiduciary, hey, what data do you actually have on me, and why are you holding it? It's about transparency, no more guessing.
Okay, so you can find out what they have and why.
Then there's the right to access. This goes a step further. You can actually ask to see the specific data they hold about you. Get a copy of it.
Like looking over their shoulder at your file?
Kinda, yeah. It lets you verify what they know. And linked to that is the right to correction.
Ah, so if it's wrong.
If it's wrong or incomplete, you have the right to get it fixed. Think about how important that is for, say, medical records or financial details. Accuracy is crucial.
Absolutely. You don't want mistakes there.
Definitely not. Then there's a big one, the right to deletion or erasure.
The unsend button for your data?
Hey, something like that. If the data is no longer needed for the original purpose it was collected for, or maybe you withdraw your consent, you can ask them to delete it.
That sounds powerful. Helps limit your exposure if there's a breach down the line too, I guess.
Exactly. It reduces your digital footprint over time. And finally, there's the right to grievance redressal.
Okay, what's that?
If things go wrong, if you feel your rights haven't been respected, you have a formal way to complain.
Yeah.
You can take your case to the new Data Protection Board of India.
The referee.
The referee, exactly. They investigate and make sure everyone's playing fair, and they can impose penalties if they're not. So these rights together, they really do put a lot more control back in your hands.
Okay, so individuals get these rights. That means the data fiduciaries, the companies collecting the data, they have a lot more they need to do, right? A whole list of obligations.
Oh, absolutely. The burden is definitely on them.
Yeah.
A key one is transparency. We touched on it with the right to information, but it's a core obligation for them too.
They have to be upfront.
Crystal clear about why they're collecting data, how they'll use it, who they might share it with, and it has to be in simple language, not hidden in pages of dense legal text. Informed consent is key here.
And then there's the big one, security.
Huge. They must implement reasonable security safeguards to protect the data they hold. This isn't optional.
What does reasonable mean, though? Is it defined?
The Act doesn't list specific technologies, which is probably smart given how fast check changes. But it means taking appropriate technical measures like encryption, access controls, and organizational measures like staff training, policies to prevent breaches, loss, or unauthorized access. It has to be proportional to the risk and the amount of data.
So no leaving customer data on an unencrypted USB stick in a cafe.
Definitely not. Or selling it off without proper consent. And tied to this is accountability.
Meaning if they mess up.
They're on the hook.
Yeah.
They can face those hefty fines we'll talk about later. They need to be able to demonstrate they've taken data protection seriously. It's about building a culture of responsibility.
Okay. And I read something about a specific role, a data protection officer.
Yes, for certain types of companies, what the Act calls significant data fiduciaries. Basically, those handling large volumes of sensitive data or posing higher risks, they have to appoint a data protection officer, or DPO.
Like an internal data sheriff.
That's a good way to put it. The DPO is responsible for advising the company on compliance, monitoring data processing, acting as the point of contact for data principals and the authorities. It's a crucial role for embedding data protection within the organization.
Got it. Transparency, security, accountability, and maybe a DPO. Seems like a lot for businesses to handle.
It is a significant shift, no doubt about it.
Now, let's talk about probably the most talked about part of this whole thing, the elephant in the room, maybe? Cross-border data transfers?
Yes. This is definitely where a lot of the current discussion and maybe some anxiety is focused.
So what's the deal? Can data leave India or not?
Okay, so the Act itself says, basically, personal data can be transferred outside India to any country, unless the central government specifically puts that country on a blacklist.
So it's allowed by default unless explicitly blocked.
That's the framework. It's a shift from, say, needing prior approval for everything. But here's the catch.
There's always a catch.
Right. As of now, there is no blacklist. We don't know which countries might end up on it, or even, crucially, what the criteria for blacklisting would be.
It's a complete uncertainty.
Pretty much. And that's what's making multinational companies, well, sweat a bit. They rely on data flowing seamlessly across borders for everything. Cloud services, global HR systems, customer support, analytics.
It's how global business works.
It absolutely is.
Oh.
If you suddenly can't transfer data reliably to your processing center in, say, Singapore or the US, or if you're worried it might be blocked with little warning, it throws a huge spanner in the works. It impacts operations, planning, investment.
And it feels different from other big regulations like Europe's GDPR.
It does. GDPR has things like adequacy decisions, where the EU formally says, okay, this country's laws offer good enough protection so data can flow more easily. India's current approach doesn't have that clear mechanism up front.
Could that cause problems? Like trade disputes? It's possible. International agreements like GATS, the General Agreement on Trade and Services, touch on data flows. If restrictions are seen as arbitrary or protectionist, it could lead to challenges. Plus, you've got existing rules in India for specific sectors, like insurance.
The IRDAI rules.
Exactly. From 2017, they already restrict some data, leaving India in the insurance sector. So companies might be juggling multiple sets of rules. For businesses trying to plan long-term, this lack of clarity around the blacklist criteria is a major headache.
It sounds like navigating a maze blindfolded.
That's not a bad analogy. There's potential flexibility for India strategically, but the cost right now is business certainty.
Okay, so we have rights, obligations, this complex cross-border piece. Who enforces all of this? Who holds people accountable?
That's the job of the newly established Data Protection Board of India.
The referee we mentioned earlier.
Exactly. This board is the designated authority. They're tasked with investigating complaints from individuals, conducting inquiries into potential breaches or non-compliance by companies, and importantly, imposing penalties. So they have real power.
They do. How they choose to exercise that power, whether they focus more on guidance and warnings initially or come down hard with fines, will really set the tone. Their interpretation and enforcement decisions will be watched very closely.
And about those fines, you mentioned they were hefty.
Oh yeah. The Act allows for penalties up to a whopping Rs 250 crore.
250 crore. What's that in dollars again?
It's around $30 million USD, give or take, depending on the exchange rate.
Wow. That's significant. That's not pocket change, even for big tech.
Absolutely not. It's designed to be a serious deterrent. Penalties can be applied for various violations failing on security measures, not respecting data principal rights, breaches related to children's data, messing up cross-border transfers if and when those rules are clear. It really underscores the need for companies to take this seriously.
So compliance is obviously crucial. But what are the real-world challenges for businesses, especially smaller ones?
That's a really important point. For small and medium enterprises, SMEs, complying with the DPDP Act could be a significant hurdle.
How so?
Well, they might not have dedicated legal or IT security teams. They might need to invest heavily in upgrading their systems, maybe moving to more secure cloud platforms. They'll definitely need to train their staff on the new rules and procedures. Appointing a DPO, even if not strictly mandated for all, might be necessary but costly.
It's like learning a whole new language operationally.
It really is. It takes time, resources, expertise. Larger companies often have more resources to adapt, but even they are watching carefully, especially that cross-border situation we discussed. The uncertainty there affects big players just as much, if not more, given their scale.
So it really comes down to this fundamental question, doesn't it? Can India successfully walk this tightrope?
Exactly. Can they protect personal data robustly, which is clearly the goal and a constitutional mandate now, while also ensuring that businesses, innovation, and the digital economy can continue to thrive?
It's the classic balancing act.
A very delicate one. Getting the implementation right, providing clarity on gray areas like the transfer rules, ensuring enforcement is fair and proportionate. All that will be critical. It's like trying to, eat soup with a fork. Possible, but messy if you're not careful.
Okay, so wrapping this up, what's the big picture takeaway here?
Well, India's Digital Personal Data Protection Act is a landmark piece of legislation. It's a huge step forward in regulating the digital world within India and for anyone interacting with it. Whether you're just an individual online or running a business, understanding this law is becoming essential.
It really reshapes the landscape.
Absolutely. And just to remind everyone listening, those draft rules for 2025, which will fill in some of the operational details, are open for public feedback until February 18th, 2025 at Innovate India.
So this is your chance to actually have a say.
It really is. Your input could genuinely help refine how this law works in practice. It's a chance to contribute to shaping something really impactful.
We've covered a lot today, from your rights as a data principal, the obligations on businesses, the complexities of data transfers, the enforcement. It definitely leaves us with a big thought, doesn't it?
As technology keeps accelerating and data flows become even more global, more interconnected.
Can any single country's data protection law, however strong, really stand alone effectively?
Mhm.
Or are we inevitably moving towards some kind of more unified global standard for digital privacy?
That's the big question, isn't it?
Well,
Something to definitely ponder as we all navigate this increasingly digital world.